This is for the administrative agencies. They are here to make the corrections. Charges can only be levied against an administrative agency by the American people and cannot be levied against an administrative agency against the American people. The administrative agency cannot be a plaintiff. They cannot bring the charges. That's why you'll see in many cases who is the plaintiff? The people. They've created a fictitious real party in interest to gain entrance into this court to prosecute the American people, who they assume is an administrative agency. So they're assuming that we are an administrative agency and or the beneficiary with no rights. They create a fictitious real party in interest to bring this action in fraud, and that's how they've gotten out of control. These administrative courts who gained their authority under Title V were designed to make the corrections within public offices, to make them more efficient and to hold agencies and officers thereof accountable for their actions. These administrative courts, only the people can bring the charges for the corrections, and the American people are always the plaintiff harmed party. These courts have no jurisdiction over the people. No agency has the authority to bring charges against the American people or their private rights and or property in administrative court. These are our courts. They were created for our use. What we're doing today at Legal Registries is making the corrections, bringing these administrative courts back into compliance so that we can use them to prosecute our claims and our grievances against these administrative agencies. And who are these administrative agencies? Number one, the banks. Number two, the IRS. The banks, they are all sanctioned by the corporate United States. They all are incorporated and sanctioned through the United States, and therefore are an administrative agency of the United States, and therefore are an administrative agency that we can prosecute our grievances against right here. Now, we can get this administrative judgment. All right, we can get that easy enough. That says that the banks are committing fraud, that there is no loan. They're guilty of securities fraud, bankruptcy fraud, and everything. So we can do that. All we need to do is get the courts to come in compliance and operate the way they're supposed to, and now we can adjudicate our grievances against the banks with our private judgments. And that's what we do here. So what is really going on? When we go into these administrative courts, the parties assume, that big word again, that our straw man transmitting utility is an administrative agency. All right? That we are the beneficiary having no rights. And on top of that, the plaintiff, the bank, has created a fictitious real party in interest in fraud. So it's clear, under these assumptions, you can see, here's what's going on when we go into court. Here's why we're getting beat up. As a beneficiary, we have absolutely no rights. And that is, we are the trustee. We are the trustee of the straw man account, or the transmitting utility. All right? We are the trustor, because 100% of the value came from us. That leaves us in the most powerful position in the trust, the trustor. The trustor has a responsibility to, or the ability, power and authority to terminate and reappoint the trustee. The trustee operates the trust on behalf of the trustor. We are the trustee. The United States appointed us as the trustee with the responsibility for operating the account for settling all affairs of the transmitting utility. When we fail to stand up and execute our duties as trustee, they appoint a substitute trustee and they assume that we are the beneficiary with no rights. All right? That's why we're in this position. Because we have failed through our own ignorance, and that's because of all the propaganda we've been fed in our schools for all our entire lives. They assume that we are the beneficiary with no rights. And they assume that we are an administrative agency. These are two assumptions that we have to counter, and we do counter in our paperwork. The notary presentment under seal, notice and declaration of trustee. The plaintiff in this matter is an administrative agency under Administrative Procedure Act having fraudulently created a fictitious real party in interest to initiate this action against the private property of the real party in interest, a real living American being. The alleged plaintiff is using this administrative court either knowingly or otherwise and employing terrorist tactics to extort funds from the real party in interest. The alleged plaintiff is fraudulently attempting to obtain an ex post facto lien right against the private property of a private American for the purpose of holding said private property hostage as surety to create and fund counterfeit securities for their own unjust enrichment. The alleged plaintiff is fraudulently using this court to pillage and plunder the private property of the American people. This is what we're telling the courts. The plaintiff is an administrative agency, and therefore they can't possibly be the real party in interest. All right, we lay this all out for the courts. There's a fraud going on in your court here, and we're not quite sure if you're a party to it or not. But if you are, we're going to document it and hold you accountable. I hereby notice this administrative court of the fraud and tender this charging document for immediate prosecution. What we're doing, we put the accusations before the court. We tell them, hey, we got a problem here. As trustee, I've just analyzed this case and we got some major fraud going on, and I'm here to make the corrections. You know, whenever you come in as a trustee and there's fraud, you make these accusations, everything stops. It takes everything back to square one. And it gives us an opportunity to determine whether the court is going to be a party to the fraud or whether they're going to do what they're supposed to do.